Hi, good morning, everybody. My name is Akinkunmi Akinwunmi, and I'm glad to be here this morning. I'll be discussing I'll be discussing um, other technology contracts. Other technology contracts. To provide a bit of background about myself, I work with the law firm of Paragon Advisors. I also lecture at the University of London, the distance learning program. I specialize in technology, media, and telecoms law, and I'm the author of the book, The Nigerian Internet Law. All right. So today under the topic, other technology contracts, I'll be looking at non-disclosure agreements, business process outsourcing structure and agreement, technology transfer agreement, work for hire agreement, video game licensing, and ebook publishing agreement. So let's just dive in. I believe as lawyers and as tech enthusiasts or developers, we must have heard of the term non-disclosure agreement. And it simply means the agreement that seeks to ensure that the sensitive information of your tech company or about your product remains secret and is protected. Okay, and so the agreement places an obligation on the recipient of your information to ensure that the information received remains confidential. All right. Now, NDAs in other agreements are being referred or have been referred to as confidentiality agreements, secrecy agreement, proprietary information agreement, but they all seek to achieve the same thing, which is to protect sensitive information. And when you have some clauses in your agreement, in an agreement that seeks to keep information confidential, it still works as you protecting your information. But the right approach really would be to have a separate non-disclosure agreement. Okay. Now, when do we use non-disclosure agreements really? When do we use non-disclosure agreements? All right. So we use as a tech company or when advising your clients who happen to be tech startups, what you can do is that to say that each time they intend to share their information, their invention, information about their invention or business plan or products or concepts with prospective investors, partners, agents, and employees, then they will need to put in place a NDA, all right? But one cogent issue which I have also realized in the course of advising tech startup is trying to get a prospective investor to sign an NDA. All right. So because the approach from the investor has always been, hey, you've come here to ask me to invest in your company, for me to put my money in your business. You can't be asking me to sign an NDA, especially when you're trying to get investors within Nigeria. All right. But what I've always told these clients is that you need to explain to this prospective investor that I trust you, but I just want this to be in place, to formalize things and, just to cover my back and ensure that my invention and my product is protected. And I believe that you always oblige them in doing this. All right, so when should you also use an NDA as a tech company? When you intend to present your technology to a potential licensee, distributor, or buyer. All right, so you need to put an NDA in place there. Okay, if you intend to permit a third party or vendor to access your IT infrastructure, then you also need to put an NDA in place. All right, so as a tech company, you have some vendors who probably will be handling your data. They provide database service, or those that will providing cyber security, okay, or those who would come periodically to help ensure that your IT infrastructure are in place. Okay, and you as a tech company, for example, if you're in in fintech space, when you're integrating your platform with a payment gateway, it also means that you'll be sharing this information, and there will be a need for you to put an NDA in place. And in respect of employees, which is very, very important, all right, you'll be sharing your concept, your ideas with employees, and you need to put an NDA in place to protect the sensitive information. And so what's not covered by NDA? NDA will not cover information already in the public domain. It will not cover information that the recipient got without you disclosing same, okay? It will also not cover information that the recipient got independently without reference to or using the information you disclosed, all right? And lastly, NDA would also not apply to instances or instances where a witness is compelled, although that is not absolute, all right? Because when you look at sections 183, 184, and 185 of the Evidence Act, all right, when you read these sections together, you realize that although the courts have the power to compel a witness, the witness may or may not choose to disclose such information. All right. And NDAs can be unilateral or mutual. So a unilateral NDA would mean an NDA in which one party will be making all the disclosures. All right. So as a tech company, or when you're advising a tech startup, okay, you need to ask them. So in this potential transaction, or what we intend working on at the moment, who will be making the disclosure? Who is making the disclosure? Would you be making the disclosure? Will the other party be making the disclosure, or will all the parties be making the disclosure? So if your client is the one making all the disclosures, then you would have to advise that a unilateral NDA should be in place. And that would mean that the recipient, that is the other party, will sign the NDA, all right? Right. Examples of that would be employees, right? When you engage someone to work with you, to work with in your tech startup, you need to put an NDA in place, as I mentioned earlier, all right? And where a vendor will be able to access your IT infrastructure or sensitive information, you need to also put an NDA in place. Why? Because you are the one making all the disclosures. Yeah. Okay. Again, the second one is mutual, the mutual NDA, all right? And this applies where both parties will be making disclosures, all right? So here, all the parties will have to sign, okay? If sensitive information will be exchanged, then all the parties will have to sign. And examples are where you're working on an M&A transaction, okay? In that instance, both parties will be sharing information, Guys will be carrying out due diligence. Everybody wants to look at wants to know whatever skeleton the other party has in its cupboard. So you want to sign an NDA so that if peradventure the transaction doesn't work out, you would know that your information is protected and the other party won't use that information against you, okay? It would also, mutual NDA would also work in product manufacturer, all right, product manufacturer. I'll give you an example, okay? Samsung makes screens for iPhone, okay? Samsung makes screens for iPhone, okay? Qualcomm provides the chip in Samsung phone, okay? So you'll see that in such instance, there will be some exchange of information. Why? Because Apple will have to disclose some information to Samsung to say, hey, these are the things, this is what I intend to achieve with my next phone or with my next product. So I need the screen to be this way. I need it to be that way. All right. And the chip supplier, like Qualcomm, would also be getting some information from Samsung, from Oppo and all those other guys that use their chip. So you realize that on one hand, the maker, the phone maker, which is Samsung, and the company that is making the chip or other parts of the phone will be exchanging certain information. And in such instance, you will need to put a mutual NDA in place. So what are the key terms you'll be looking out for in an NDA? The parties, we all know the parties. So what will the parties, we have to state the parties, where they are located, some introduction about the parties, some information rather about the parties, all right? You have to then define confidential information, okay? The parties need to agree on what information are confidential, what information are sensitive and things like that. Then you have to then state the obligation of the recipients. Okay, what are his obligations? What are the things he needs to do? One of the obligations really is to ensure that any information received is used strictly for the purpose of the transaction for which it was disclosed, all right? So the recipient shouldn't use that information against you, okay? Or shouldn't use that information in now developing a product that will seek to challenge yours, all right? There can also be restriction clause in there, all right? And they will be excluded. There will also be some information excluded. Information excluded will be those things, for example, information already in the public domain, information already in the public domain, or information which the recipient got without reference to you or without you having disclosed same. Now, some remedies here would be to say that in instances where the recipient is aware that certain information from the disclosing party is out there, the recipient should inform the disclosing party, all right? Or the recipient should inform the disclosing party. And also at the end of the transaction, some of the things that you can agree on where you're representing the disclosing party is to say information received should be, if you have the information in physical format, okay, you have to return them. If it is hard copy document, you have to return them. If it's soft copy document, you have to state it in there that the recipient needs to delete those information at the end of the transaction from its system, from its server, from its backup, and anywhere that the recipient might have stored the information. Now, there's certain benefit for having an NDA in place, all right? And the most notable one is that it will help to protect your sensitive information, trade secrets, okay? Sensitive information and trade secrets. All right. And secondly, you can sue the recipient. You can sue the recipient of the information. I cited these cases in my book, The Nigerian Internet Law, and I've also provided the information here. So Waymo LLC and Uber Technologies, all right? It's a US case. In Waymo happens to be Waymo is an affiliate of Google. All right, and Waymo is a self-driving company for Google, rather. Okay, now one of its top engineers, resigned from Waymo and joined Uber. Okay, and as we all know, Uber is also working on a self-driving car. All right, apparently that employee took information about the design, the concept, the innovation, the ideas of what Google was working on for its self-driving car, and took that information to Uber. And Uber also started working on theirs. Now, Uber actually poached him because they are also working on self-driving car, and they want somebody who is a top guy to lead the team and things like that. Okay, but what then happened was that Google didn't know that their information about their self-driving car had been copied and taken to Uber until somebody from Uber had sent an email to someone in Google in-house, and in the email trail, the recipient at Google then saw that, oh, these are some information, there's some information hearing about our self-driving car. Now, by the time Google then investigated, Google realized that the employee that moved from Google to Uber was the one. Google did not only bring an action against against Uber via Waymo, but a criminal action was also commenced. The same thing in the case of Tesla Inc. and Zoox Incorporation. Okay, so those are just examples. You can sue the recipient, all right. And in court, when you sue the recipient, you can claim that damages. So damages that will be commensurate with loss of earnings. You can ask for accounts. So you can ask that party to account for income that has been made from the use of that information, and then the court can order damages to be paid to you. Criminal action can also be brought against the recipient, all right? Because when you look at sections 10 and 31, subsection 1 of the Cybercrimes Act 2015, you will find this in there. Specifically, section 31 talks about when an employee leaves your workplace, is meant to hand over the code, to hand over all access code, to hand over any information that may relate to your product, okay? To your product, to a computer program, or to a software and things like that. And where those informations have not been disclosed by that employee, and you've left the organization or resigned, then a criminal action can also be brought against them. So what are the dangers of no NDA? The first thing is that leakage of sensitive information or trade secrets, okay, can be leaked. How? So if you brought a vendor or a third party into your organization to work on your IT infrastructure, or there's an integration between your platform and maybe a payment gateway and different arrangements like that, or there's somebody that's providing database services to you. Now, if you don't have this NDA in place, it can lead to leakage of information, all right? Because the vendor or that third party will be able to access your information. And don't forget that that's an authorized access, okay? They have been authorized, that vendor has been authorized to access the information, okay? Okay, but what has happened, or what will happen in this case, will be what we call an abuse of authorized access, which means that they abuse their access to your IT infrastructure, and by copying or by selling your information or disclosing your trade secrets to competitors. Okay, and of course, in this instance, criminal actions can be brought, as I mentioned that in section 10, under section 10 of the Cybercrimes Act, there's a provision for criminal actions for abuse of authorized access. The second one is loss of competitive edge, right? Because if you don't have an NDA in place and you're trying to raise funds as a startup, or you brought in vendors who are helping, who want to help you upgrade your system and things like that. If you don't have it in place, these guys can see what makes you tick, and they can then copy your information, go out and start making similar products and and things like that. And when that happens, when your competitive edge has been affected or is under threat, it will affect your revenue. Okay, to affect your revenue. All right. So, and those are some of the dangers of not having an NDA in place. So quickly, let's talk about business process outsourcing. Business process outsourcing is a business practice in which an organization contracts a third party or vendor to perform tasks required for its operation. And such things that you may outsource include database service, cloud computing, IT analyst, software developer or software development, database service where your information is being, where an entity, an IT company is providing database service to you. That is, all your data and information about your business and your clientele are being stored, are being backed up or stored in the database server of that provider. All right. Or when you have an external IT analyst, somebody who comes periodically to your office and come to check on your system and all of that, the person would see information and and things like that. So that's also an example of outsourcing. Or software developer, maybe for back end. When we talk about back end, we're talking about the guys who are writing the codes. Okay, perhaps writing the codes using Python or using Python and Java and some other programming language, or the front end developers who are good in JS, in JavaScript, HTML and CS, or the full stack guys. So because the world is now a global village, and with the internet, you can always outsource the role of a software developer. Somebody can be in Nigeria and be working remotely for a company in the US or in the UK or in South Africa. So all this is also an example of where you can, of outsourcing, all right? Social media marketing, that's also outsourcing, all right? You will appoint somebody externally who is handling that. Legal, accounting, recruitment, customer support. These are all examples of things that you can outsource. All right. And when you're trying to structure, a business process outsourcing, one of the things you have to be aware of is the status of your entity. So are you a startup or an enterprise company? All right. Because for a startup, BPO will be more attractive. Why? Because one, you are operating on a limited budget. So that means you want to be able to take out, cost and just focus on the main things. All right. So in that instance, as a startup, you might just think, okay, let me just outsource this, outsource that. Okay. An enterprise company may not need to outsource as much as a startup would do. All right. For example, a startup may choose to outsource all of these things I've listed here, while an enterprise may choose to outsource maybe legal or social media marketing. I mean, if you're an enterprise, you probably have your IT analyst in-house, you have your software developers in-house. So you may not be outsourcing that, or outsourcing those rather. Now, you also need to know the business-related operations you want to outsource, okay? Your business-related operations, the ones you need to outsource, you need to be sure of it. And then you identify the tasks to outsource, okay? Because in outsourcing, some of those tasks may be front office or back office function. So let's look at these examples again. Database service, cloud computing, IT analyst, software development, roles, and all of these things, they are all back-end functions, okay? They are all back-end functions. Things like social media marketing, customer support, these are front-end functions. Okay, so you need to be sure of what you want to outsource. All right, now you then need to decide on what type of BPO you want to use. What type of BPO do you intend to use? So is it the offshore or nearshore or onshore? When we say offshore, it means you as an entity, whether as a startup company or enterprise company, you're engaging a company outside Nigeria. So there's a company, maybe you're in Nigeria, but you have an entity in the US, or you have an entity in the UK or somewhere like that. That will qualify as offshore. Nearshore would be you engaging a vendor that's in your neighborhood, okay? That's in your neighborhood. So You are a company in Nigeria, but you've engaged a vendor in, say, Ghana or in Togo or in Benin Republic to provide some services to you. The third type would be onshore. Onshore means you've engaged a vendor or a third party within your country. So you're in Nigeria, then you engage somebody within Nigeria or an entity within Nigeria to provide those services to you. All right. To provide those services to you. Okay. So now, we also need to talk about the regulatory concerns. So what are the regulatory concerns? Regulatory concerns, and you have to also look at some regulatory concerns, all right? Especially as it relates to data localization, all right? As it relates to data localization, what data are you allowed under applicable regulations in Nigeria to store in Nigeria, or that you can then store with someone else outside Nigeria. All right, so you have to consider these things. Now, in your BPO agreement, there are some key terms you also need to note, right? The parties, okay? The parties, that's straightforward. Commencement and duration. So what's the duration of it? Is it for X number of years? When will it commence? You need to also include a confidentiality clause, right? You need to include confidentiality clause in there. Make provision for legal compliance. Provision for legal compliance to say that the company you've outsourced to have an obligation to at all times comply with applicable regulations, with applicable laws and regulations, all right? So that you will not, and so that its failure, the failure of that vendor or third party would not jeopardize or create any form of liability for you. And you also need to agree on fees and the fees and payment terms, all right? Auditing rights. So auditing rights here, we're concerned about trying to know what information that the vendor or third party has about you. So you want to be able to know those information and to at least take stock of the information and be sure, okay, these are the information that you have about me and things like that. You need to also stipulate dispute resolution process. Okay, what happens if we're in dispute? How do we resolve it? What is the duration for amicable settlement? When should we approach the court, or when should we look at the option of ADR, alternative dispute resolution mechanism? And you then need to state the rights and obligations of the parties. All right, the rights and obligations of the parties here as the one outsourcing. You would state these are the services that I'm outsourcing to you, and these are my expectations. The other parties would also say I'm able to provide these services, that and things like that. Data security is very important, especially for BPOs. It's very important. Why? Because when you outsource, when you outsource and that party, that vendor or third party experience a data leakage or a data breach, it will impact you, right? Because not only will your information and the information of your customers be disclosed, but your customers can also sue you directly for breach of contract. Okay, they can sue you directly for breach of contract, for breaching your privacy policy and the confidentiality arrangement which you have with them as customers. All right, so you need to be sure that the vendor you are outsourcing to has a good data security mechanism in place. Okay, they are apparatus in place to ensure that data received by that vendor are well protected. And then, of course, you have to agree on governing law. Now, the relationship between you should remain that of an independent contractor. So he's an independent contractor. And in fact, because of him being an independent contractor is one of the reasons why you've decided to outsource so that you can take care of costs. Now, proprietary rights, you need to be firm on this. So be firm on this to say anything you do as the vendor, as a vendor in respect or under this agreement belongs to me. So you have to state that force majeure is also pertinent. Force majeure is also pertinent. So force majeure are circumstances or events that prevents a party from being able to fulfill its obligations under a contract. So you need to provide for force majeure instances. And then the termination clause and things that can lead to termination, or instances where the parties may try to amicably remedy the breach and then continue. Okay, so the upside of BPOs, the first thing is cost, right? Because if we look at everything mentioned, if you have to, as a startup, if you have to engage an IT analyst, engage a software developer, engage an accountant, engage customer service guys, and engage everybody in-house. As a startup, that may be too much for you. So, and when you engage them, you are not only do you have to pay salaries, you also need to provide health insurance. You also need to take care of pension and some other things like that. But when you outsource, you just do away with that. You pay a fee to the vendor. That burden will be lifted off you. So that means you don't have to worry about paying pension, health insurance, and paying salaries. So that won't work. That won't be there anymore. Now, it will enable you as a startup company or enterprise to focus on key functions. Okay, so you're focusing on the main things that you want to do. What are the things that are expedient for the success of our organization, or expedient for the profitability of our entity? Okay, so that you focus on that. And then another upside is speed and efficiency. All right, speed and efficiency. Okay, because the vendor you've outsourced to is probably doing that, or that's all that vendor does. So the vendor would take it seriously. The vendor has a timeline for giving feedback, a timeline for delivering results, and things like that. So you are aware of it, and you can always project as to when to receive service that you've asked to be rendered, that you've asked the vendor to render, rather. Now, the downside of BPO, political instability or civil unrest, okay, that can happen. If there's political instability in a country or civil unrest, it will impact the vendor that you've outsourced to, okay, because the vendor or the guys working with the vendor may not be able to get to their workplace, and perhaps may need to work from home. And even in working from home, perhaps they do not have all the information or all the apparatus required to provide the service. Okay, security, that is the security of information received. Okay, because if you are outsourcing, you need to be sure that that vendor has enough security in place. Okay, enough security in place, or infrastructure that would ensure information received are well protected. Another downside is data leaks or breaches, which I've mentioned earlier. So data leaks is when the party that has received information, the information sort of, disclose it to people and to other people. Data breach would be when an unauthorized person access the IT infrastructure of the recipient of that information, and then takes the information, sells it on a dark web and places like that. Excuse me. Now, another downside of BPO is that there's a tendency to underestimate cost. There's a tendency to underestimate cost, because when you look at this downside, if there's a data breach, all right, and your customer's information were stolen from the vendor, your customers will sue you. Okay, so you can't tell your customers, oh, I outsourced to somebody, and so it is not my fault that your information was stolen. No, they won't listen to that. All right, they won't listen to that. All right, so that's a big cost. Again, you might have regulators coming after you. Okay, you might have regulators also coming after you and saying, oh, you have to pay a fine and things like that. Okay. So let's look at the next one, technology transfer. Now, when we talk about technology transfer, and here our focus is on technology transfer agreement, okay? Here it means when a company intends to assign or license to another entity registered industrial and intellectual property rights, as well as technical assistance and know-how. So there's a company in the US, okay? There's a company in the US who intends to assign onto you or license to you its registered intellectual property. Okay, that may be a patent, that may be a trademark, or that may be something covered by copyright, okay, or to offer technical assistance and know-how to you. So that's a sort of a broad definition of what a TTA is. And there's 7 key terms about TTA, and one of the things is the parties. All right, the parties. You have to disclose who the parties are. The purpose has to be stated. Okay, the purpose has to be stated briefly in there. Okay, that the purpose of the agreement is X and Y. Take for example, the purpose of the TTA can be to say that this is an agreement. This agreement, you can say, for example, that this agreement is to permit perhaps company A, let's just say company A and company B now. So this agreement is to permit company A to make, use, sell, and sell product X in the territory as defined in the agreement with the help of the technical assistance and know-how licensed under this agreement by company B and under the licensed patents as may be defined in the agreement. So that's just an example of what you can state in the purpose. You also have to be clear about the effective date. Okay, you have to be clear about the effective date, as I'll touch on that subsequently. Okay, you need to also mention the right conferred. So what rights are you conferring under the agreement? So you need to be sure, you need to state specifically the rights you've conferred, okay, in respect of a particular software or in respect of a particular product, okay. And the representation of the parties. The representation of the parties of the company who is transferring its technology will be to say, oh, I am licensed, I have a license for this software, or I have the patent, or I have the copyright or trademark for this and that, and therefore I have the capacity to then, to allow this party B to have this, to have access to this software, okay? And the representation of the other party, okay, which is the recipient, perhaps here in Nigeria, would be to ensure that it will comply with anything, with the rules that may be applicable, okay, the licensing rules, okay, and to comply with any terms and conditions under the current TTA, okay, and that may include that we've only provided you with access to use this information, okay, to advance your business here in Nigeria, but you as the entity receiving it in Nigeria, you cannot go ahead to sub-license. That's just an example of what we're looking at there. You have to also define some certain things, okay? So for an example is license improvement. Here we're saying that if license improvements will mean that if there's any improvement made by that foreign entity on the products or on the software which it is transferring to the entity in Nigeria, then that such improvements, the entity in Nigeria should be allowed to be able to, the entity in Nigeria should be allowed to be able to access that information. Okay, you can also include what we call the grant back. Okay, the grant back is saying that any improvement that is made, any improvements made by the Nigerian entity to the product, okay, to the product or to the software, then that Nigerian entity would have to transfer everything back to the foreign company. All right. Why? The reason is because the improvement stems from the software which the foreign entity has shared with the Nigerian entity. In other words, the Nigerian entity would not have been able to make such improvements without having access to the information, to the technical know-how, to the license of the foreign entity. Okay, you also have to specify the territory. Okay, you have to specify the territory where this would apply to. Infringement provisions have to be, you have to make provision for infringement. Okay, what happens when there's an infringement? What happens when there's an infringement if the entity in Nigeria infringes, or if the entity in Nigeria becomes aware of an infringement, or if the entity in Nigeria becomes aware of an infringement and informs the foreign entity that owns the technology, what should happen or what should be done? All these things you have to state in there. Improvement, mentioned improvement earlier. Then indemnification, you have to make provision for indemnification. All right. So saying that the entity in Nigeria will indemnify the foreign company that is sharing its technology with the Nigerian entity if the foreign entity suffers any form of loss or liability as a result of the negligence recklessness, or actions or inactions of the Nigerian entity as it relates to that technology. All right. Okay. The indemnity can also go both ways. Okay, can also go both ways. For example, if there's been the Nigerian entity is aware that there's been a potential infringement by another company, and informs the owner of the technology, which is the foreign company, and the foreign company is supposed to sort of take steps, perhaps litigate and things like that. But the foreign company then says, you know what, we are not going to litigate, all right? And if the foreign company does not litigate, right, if the Nigerian company realizes that if the foreign company does not litigate, its failure to litigate might affect its business in Nigeria. Okay, so meaning that if the foreign company had litigated the infringement, then there's the tendency the court might give judgment in favor of that foreign entity. But if the court gives judgment in favor of that foreign entity, then it also means that the business of the Nigerian entity is also protected. But if the foreign company does not litigate, right, it can affect the Nigerian entity, because the Nigerian entity will now we'll now have a local competitor here. Okay, we now have a local competitor here who is probably providing the same, services. All right, who's probably providing the same services. Yeah. Or the indemnity could also work in the form of saying, if the foreign entity choose not to litigate, then you can't permit me as a Nigerian entity to litigate, and then you can compensate me for the cost of litigation, because in any ways, you as the foreign entity, you would also take benefit. You also benefit from me litigating. Okay, and then you make provision for termination, dispute resolution, and governing law and things like that. All right. So let's talk about registration of TTA. Let's talk about registration of TTA, okay, of technology transfer agreement. So when you enter into a technology transfer agreement, you can register it in Nigeria with the National Office for Technology Acquisition and Promotion. Okay, so you can register it with NOTAP, which is NOTAP. And the registration under NOTAP Act is required to be done not later than 60 days from the execution date. So not later than 60 days from the execution date, you're required to register with NOTAP. Okay, you're required to register it with NOTAP. Now, but there's also a provision in the NOTAP guideline that states the registration should be within 30 days from effective date. All right. So the NOTAP Act says not later than 60 days from execution date, and the NOTAP guideline says 30 days from effective date. So that creates a bit of a conflict. All right, because the execution date of the TTA may not be the same as the effective date. But since the position of the law has always been that the provision of an act of the National Assembly supersedes a regulation, a guideline, it is safe to say that we can rely more on the provision of the NOTAP Act as it relates to registration. Although this has not been litigated in court, but we can rely more on that. Now, NOTAP may refuse to register for example, if the technology is freely available in Nigeria. All right. Now, the benefit of registering a TTA is that it will enable the Nigerian entity to pay the licensor or repatriate profits and fees, which may be due under the TTA to the foreign entity. Okay, so let's talk about work for hire. Let's talk about work for hire. Now, when we talk about work for hire agreement, okay? A work for hire agreement is that in which you've engaged an independent contractor, okay? You've engaged an independent contractor, and then you've then stated it in there that that contractor would give up his right to the work created, okay? Will give up the right to the work created. And this is very important. Why? Because when it comes to work, especially copyright work, so when we talk about copyright, when we talk about work that are protected by copyright, we're talking about literary work, we're talking about musical work, sound recordings, cinematographic, artistic work. So if you've engaged somebody to do any of this, to carry out any of these works protected under copyright, the right of ownership vests in him by virtue of Section 10(1) of the Copyright Act. And so before you as the hirer or employee can say that I'm the owner, you then need to enter into this agreement under which that independent contractor will then assign the copyright in that work to you. All right. So I'll give you an example. If you are a startup company and you have a great idea you want to execute, so you've engaged a freelance software developer to help you write the codes and things like that. As we all know, the Copyright Act protects computer programs as literary work, as a literary work. All right. And because the ownership vests initially in the author, it then means that though you're the one who paid for the service, the ownership of the code written by that developer vests in him. All right, and so he can do anything he wants with it. But for you to then claim ownership of that code, you then need to specify or state in your agreement with him that he has agreed, or you have to state in there, have an assignment clause. Okay, can have an assignment clause in your contract with him, or you can have a work for hire agreement in place with him. It's saying that he has agreed, or he hereby assigns to you the code written in respect of that particular software. Okay, respect of that particular software. All right. Because until you have that in place, the ownership will still vest in that software developer. So what are some things you'll find in a work for hire agreement? The parties, the purpose. Okay, you have to state the purpose. You have to define the roles of the parties. You have to talk about the work that you've hired the person to do. So is it a literary work? Is it an artistic work? So you've hired a person to write codes, or you've hired a person to come up with a design, for your entity or for your tech company and things like that. So you have to state it in there. You have to specify the duration, the delivery date. Okay, you have to also state the fees, and then the ownership clause is very important. That's the most important aspect of this work for hire agreement. Okay, in the ownership clause, you have to then specifically state that you've agreed to vest the ownership of anything you do under this agreement to me as your hirer. Okay, as your hirer. Because if you do not do that, then you'll be able to do anything. The software developer will be able to do anything with it. All right. Dispute resolution, governing law, you have to also have that in place. Let's talk about the third one, which is video game licensing. Okay, video game licensing. And this is actually a big one nowadays. Video game licensing. So before we talk about video game licensing, let's talk about video game and copyright. So copyright applies to video game, all right? Copyright applies to video game, and it protects different aspects of a video game, okay? Because in a video game, whether you're playing Fortnite or you're playing soccer, or you're playing is it motor racing, or any of the games which I've mentioned here, Call of Duty, Need for Speed, Battleground or Overwatch, all of these games, you will realize certain things, right? These games have graphics in there. These games have scenes. They have different scenes. There are scripts written for the different characters there. In fact, some characters have certain moves. Okay, they have certain moves. For example, if it is Overwatch, you're playing Mortal Kombat. Certain fighters have some things you can press on the pad, and that will trigger a certain reaction. So So all of these things can be protected or are protected by copyright. So copyright will protect scenarios, choreographic works, stories, and computer programs as literary works. Okay, it will protect character images as artistic work. There will also be musical work there because there will be sound, right? So the sound recording and musical work will also be protected by copyright. And the musical work then depends. Okay, it might be that the video game actually the music in the video game is not original, to the creator, and it's only the creator of the video game has only been licensed to use someone else's music. All right, so that's it about the music work and sound recording. Now let's talk about the video game and creators. Okay, when we talk about video game and creators, because copyright protects video game, and so video game creators, their investment, their effort, their hard work and labor is protected, so long as sufficient effort has been expended to give that video game an original character, and it has been fixed in any definite medium of expression. All right. All right. So Section 1 of Copyright Act would protect them. And so a video game creator or video game creators have exclusive rights to their work. They have exclusive right to their work, including the right to license. And that is where video game licensing stems from. Okay, so video game licensing then involves a video game creator, licensing his work to different people. And when we talk about video game licensing, it involves numerous parties. So you have the game developer, which is the video game creator. You have publishers. Okay, publisher of a video game can be Apple. So when you go to the Apple Store, and you can download Fortnite. At the moment, you can't really download Fortnite because of the case which I mentioned here, Epic Games and Apple. I'll come to that shortly. Okay, publisher will be, for example, Google, when you download game from Google Play Store, Apple, Sony, these guys are publishers. Okay, these guys are publishers of the game. Now, game developers can be EA Sports, okay, EA Sports or Konami. So these guys are game developers. Sports, and if the game you've developed has to do with maybe football or any kind of sport, then sport organizations are involved, and there's also end users. So a game developer would sort of need to have agreements and have agreements with these people and have to be licensed. Okay.
Sir,
Yep.
sir, you have 5 minutes to go, sir. So
Okay.
you can just round up and
Thank you.
thank you very much.
All right. So if you've developed a game, say for example PES or FIFA, or if it's PES or say or FIFA game, now you would have to get an approval or authorization from FIFA before you can use the name of those footballers, their images or characters similar to them. And also there's an agreement with end users. So end users are you and I that will download the game from perhaps the App Store or from Google Play Store. Okay. Now, when we talk about video game licensing, it is very pivotal. It's pivotal to video game manufacturing, advertising, and marketing, because every game you see, there's a licensing, there are several licenses that have been granted in respect of it. And a game developer may have issues with any of the parties. Epic, a recent case is Epic Games and Apple, Epic Games and Google. And Epic Games are the guys who developed Fortnite, and they currently have an issue with Apple as it relates to fees. right? So let's just move ahead. So in respect of video game licensing, you have to make provision for the license, the license granted, royalties and payments, giveaway restrictions. Giveaway restrictions here, you're saying that the license I've given to you does not give you the right to sublicense it to somebody else. You also stipulate the territory, stipulate the territory, the use of trademark, recently, Ibrahimovic is one of the footballers. He's a footballer and he plays for AC Milan. He came on Twitter, was it 2 weeks ago, and he was saying, "Oh, somebody has been profiting from the use of my name and my image." All right, but it is indirectly accusing EA Sports. EA Sports makes football game and accusing EA Sports and FIFA. So at the moment, we do not know whether he is going to sue, but that's just an example of an issue that may arise when we talk about video game. Okay, so let's talk about ebook publishing in the next 2 or 3 minutes. So ebook publishing refers to the publication of a book in a digital form, all right? The world now, you can publish your book online. You may choose to publish your book by yourself, or you can get an online publisher who then publishes the book for you in digital format. But you then need to have an agreement in place. And this agreement will cover ownership of copyright. And in respect of ownership of copyright, so it will have parties, purpose, ownership of copyright. In respect of ownership of copyright, you have to ensure that the copyright to the work is vested or remains vested in you. And also that rights not specifically granted are vested in you as the creator of that work. Okay? And rights granted may be exclusive or non-exclusive. In other words, it may be, you might say, "Oh, I'm having an exclusive arrangement with this publishing company to publish for me," or it's non-exclusive, and both have their advantage and disadvantages. All right. And rights and obligations of the parties need to be stated. Royalties, payment of royalties, you need to be clear on that. So do you want royalties to be paid per time or per transaction? So per time would mean that over at the end of 1 year, you will pay me royalty at a particular percentage, or you will pay me X% from the sale of each book as royalty. So you can, depending on how you want to do it. You can also talk about sub-licensing, saying, can the publisher sub-license or can he not sub-license? So things like that, I'll have to skip and talk about quickly about the music licensing agreement. So here, the music licensing agreement, this is where you have different, you have artists, creators of artistic works, licensing their work. And the licensing of their work may be, their work or sound recording may be for use as caller tunes. When you call someone, you probably hear somebody's song going on in the background, or maybe for use on TV, radio, in video games. I mentioned video games earlier, or in movies, or for advert. So all this is backed by music licensing agreement. And a music licensing agreement ensures that you as an artist reap the fruit of your labor. Because it's not enough for you to go to the studio and then to do the song and expect to only make money from sale of your music. Nowadays songs are on YouTube every time, so you have to look for creative ways of making money, including the use of your song in video games, movies, and ads and things like that. So you may license a song, a set of songs, or your entire work. But licensing your entire work, you also have to think about it well, okay? Except where you're sure that you'll be paid very well for it. So in a music licensing agreement, we'll talk about the parties, the scope, the rights granted. You also have to consider third-party rights. Okay, so if as a lawyer, if you're representing, if you're putting together a music license agreement, you have to consider third-party rights. So did your client, as the artist, did he co-write the song with somebody? Did he co-perform the song? That is, did he feature somebody? What is the interest of the record label as it relates to that particular song? How about the music publisher? Because a record label is different from publisher. All right.
You have 1 minute.
All right. Thank you. Yeah, thank you. All right. So, okay. so and you also have to mention rights and obligations that will survive the termination of the agreement. Okay, so quickly, I just also want to say that some of the things which I've mentioned, you can find them in my book, The Nigerian Internet Law. So you can get a 10% discount if you purchase 2 or more copies and free delivery within Lagos. And you can send emails to this number or WhatsApp number. All right. Thank you. Please, do you have any question? Okay, let me just check the Q&A and see what we have. Okay. So the question here says, what do you mean that the court order is not absolute? It's not absolute. Please break it down. Now, in my presentation, I mentioned it here. It's not absolute because now the court can compel somebody to appear in court. The court can compel somebody to appear in court, all right? But when you in court to give evidence, but when you then read together sections 183, 184, and 185 of the Evidence Act 2011, what it tells us is that though the court can compel somebody to come to court to give evidence, it's within the discretion of that person to determine whether or not to give evidence in respect of the request, or to give evidence in respect of the information which that person has been called to testify on. So that's what I mean. So by the time we read, just check section 183, 184, and 185, and you would get that you get more details from that. Please, can you expand on? Okay, I'll go to that. Please, can you expand on the legal compliance for BPO agreement? Okay, legal compliance for BPO agreement. So what I'm talking about here in respect of legal compliance for BPO agreement is that you want to ensure that the vendor you have outsourced to is complying with applicable laws as it relates to its business or as it relates to its operations, okay, in its own country. Okay, in its country. Because if that entity is not in compliance, is not complying with applicable laws and regulations in its country, and the regulators go there and shut down its business, it can impact you. Okay, it then means that that aspect of your business will be suspended. Okay, will be suspended. So take for example, if for example, an entity is helping you with payment collection, all right, with payment collection, all right, or a fintech company is helping you with payment collection, and that fintech company has not obtained the required license under applicable law or regulation to carry out that business. And that means that as it relates to collection of funds on your behalf, your business will be impacted. Okay, your business will be impacted. Again, if we look at the GDPR or the NDPR, you will see the provision for appointment of data compliance officer. So if and that entity that you've outsourced to does not have a data compliance officer, and if that entity is involved in database service, it can impact your business if that entity is fined or certain steps are taken by regulators against such companies. So I'll go to the first question. But it is not easy to have a potential licensee sign an NDA when they haven't even made up their mind that they would license your product. Usually people give demos without NDA. So how do you ensure that the demo does not contain sensitive or confidential information? Well, there's no way, that's why it's called a demo. There's no way you want to give if it's a demo, it will definitely contain certain information about your business or about your product. And as advised earlier, the approach would be to sign an NDA, because when people look at your demo, they can then go ahead to create a similar product. So let me give you an example. Now, did you know that pre-2007, this has to do with Samsung and Apple. Did you know that pre-2007, the kind of phones that we had were phones that we had to press the button, they are not screen touched phones, all right? At that time, the phones that Samsung was also making, right, were also phones that you had to press the button. Now, the first set of innovation as to making phone a screen touch actually came from Apple, all right? Now, Samsung has from time for a long time been one of the vendors of Apple. And so there's this cordial relationship between them. The idea to start making screen touch phone, okay, by Samsung came after Samsung had visited the workplace of Apple, of Apple. And that was where they got the idea from. I will also give another example as it relates to the origin of Android phones, which is screen touch. That also came from, guys in the same industry trying to, just trust each other with information. You're trying to show me what you're doing and things like that. I'm like, oh, wow, that's good. But you did not know that I'm actually taking note of those things. All right. And that's how Apple now ends up having, a big competitor in the market, which is Samsung, and Android as it is. So, my advice here, the reason I've given that example is to say, when you're making demos, you have to put an NDA in place. You have to just insist, because the person might see the demo and say, I'm not interested. But the reason he's not interested is because he has seen it and believes, oh, I can do this myself. So let me just tell him I'm not interested, and tomorrow the person go ahead to make similar product. Okay, that's okay. Those are all the questions. Please, if you have any further questions, you may please send. So my email is here, akin@paragonadvisors.com.ng, or you can just, we can talk on social media, and then we can take it further. Again, if you're interested in a copy of my book, you can get the number on the screen or send an email, and one of our sales reps will have it delivered to you. Once again, I want to thank the organizers of this event for inviting me to speak. I hope we've all gained from it. All right. If you have any requests, if you need more clarification about anything I've discussed, please, you can just, All right. Thank you so much.
Hello. Hello, sir. Thank you very much, sir. Thank you very much for your presentation. Please do have a nice day. Thank you. To everyone who Mr. Akinkunmi will be starting right now. Hello, Mr. Akinkunmi.
Yeah, I can hear you. Your thing was
very sorry for the time.
No problem. This will be relatively quick because